Judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in and for the State of New York, may now draw near, give their attendance, and they will be heard.
Okay, matter of Singer, 155. Counsel, you want any rebuttal time?
Yes, Your Honor, 5 minutes, please.
5 minutes, you have it, go ahead.
Good afternoon, Your Honors. My name is Gary Freidman. This is my colleague Jeffrey Sheets. We represent Joseph Singer, the appellant. This is a proceeding to construe the last will and testament of Joseph Singer. Here, both the surrogate and the appellate division have turned established case law and legislative designed safe harbor provisions contained in SCPA 1404 and EPPL 3-3.5 and basically turned them into limitations on a potential objectant's conduct.
Where would you draw the line in terms of what someone can do before they run afoul of an terrorem clause?
Well, I think it would depend because the Bennett Commission back in 1966, when they changed DEL 126 into 3-3.5, basically rejected having a bright line test. If we're going to have a bright line test, I think that at the very least it would have to be filing objections, because in New York State, under SCPA 1410, there's only one way to contest a will, oppose probate.
Why would they have, though, the particular provisions and the particular safe harbors if they, weren't for a purpose? In other words, why isn't the bright line what it says in the statute? The particular people that you're able to
Your Honor,
depose.
it could be if the clause was properly drawn. What the point that the Bennett Commission was making is, since each clause, the way lawyers have drafted them over the years, is different from every other clause, that you have to actually construe the will.
Well, I think we're asking you about the statute. Subdivision 3D of the statute lists 4 categories of individuals for preliminary examination.
Yes, Your Honor. And if Joseph Singer's will had said that if any beneficiary takes any action other than the actions that are expressly permitted under SCPA 1404 subdivision 4...
But I think that kind of slides by the point. The particular provisions are taking into account what people put in their wills, and yet they want to encourage, where appropriate, that there be depositions of people that are going to help someone to determine whether or not to make objections. Why, again, and I don't know that there's an answer, but the question is, why don't we read the statute the way it is, and this isn't a rhetorical question, and say, all right, those are the areas where you can depose, and if you go beyond that, that's where the line is, and
because
then the clause in the will takes hold, because there isn't a statutory exception to, you know what I'm saying?
Yeah, except I would respectfully disagree, Your Honor, because we have to look at the clause first and not the statute. I mean, especially you look at some of the clauses in the older cases, like matter of
We have
Cronin.
2 clauses here. We have one that was specifically directed to Alexander.
Correct, and it says, I direct that he not contest my will, object to my will,
or oppose the
the
bill.
probate. There's only one way to contest, object, or oppose probate. You have to file objections, otherwise...
You're saying that there is a line in the statute, but that this will doesn't go up to the line?
Correct. And it could have simply said, you do anything beyond 1404 subdivision 4, you forfeit your request.
Does it
So
matter?
you have to have a direct statutory reference to that provision of the SCPA to have a will that's governed by the statute?
No, it could delineate the conduct. I mean, the cases teach us that these clauses are disfavored. They're supposed to be narrowly construed.
And the statute is designed to address that issue, no?
In part, And I mean, the whole purpose of the
You would have it
statute,
say, the proponent's witnesses, the person who prepared the will, the nominated executives, proponents of the probate proceeding, and the attorney who
prepared the will.
who prepared the will. But
Right.
aren't we reading something into the statute that's not there?
No, all 1404 says is that these are permitted pre-objection. 3-3.5 says, if you do any of these things, regardless of what the will says. I mean, I could draft the will that says, if any beneficiary takes the examination of the attesting witnesses, he or she forfeits his bequest. 3-3.5 says, no, you can't.
All
And
right,
we've
so
made a policy
your
determination.
point is that if you don't object, you're okay.
Basically,
Under this,
certainly under this clause, and especially when you construe it narrowly, because you gotta have to remember,
What about
This-
the testator's intent here?
right,
I mean, it's
absolutely, the testator's
it's
intent.
expressed in more than one provision of this will.
It's in two provisions, the language is substantially similar, and
And
it
it's
says,
fairly broad to try to restrict what Alexander can do.
I disagree, Your Honor. It says that he can't in any manner directly contest my will, object to, or oppose my will.
Or attempt to contest, object
Or-
to,
or attempt to
the
do
word
any of
The
those-
word attempt is in there.
Right. How does one attempt to contest the
Doesn't-
will?
Isn't it
if-
a possible reading of that language, that it was an attempt to be as broad as the law allows, the strongest, that a lawyer sat down to write the strongest in terrorem clause he could write?
No, because I'm not
Of course, sitting here now, we could always write a stronger one, but that's always true.
I'm not a will drafter, and it came to me as I was, formulating my argument here, that there's a clear way out of this situation if lawyers would draft them in conformance with the
As
clause.
always, in every case where there's a dispute about the meaning of a writing, when you're preparing your oral argument on appeal, you can always think of a better way to write it.
That's true, Your Honor.
But doesn't, I mean, when you look at the background, that what the rabbi was worried about was that his daughter shouldn't be upset, that nothing should happen to disturb her. Doesn't that suggest that he really wanted to prohibit the son from doing, or to prevent the son from doing anything he was allowed to prevent him from doing?
He didn't say that in his will, Your Honor. I mean, that's the idea, is that we have to construe, using, with the sympathetic reading of the will as a whole, and also, when we weigh that against the state's policy interest in seeing that only valid wills are admitted to probate, under SCPA 1408, the court has a
but didn't he
duty.
do, but again, just playing devil's advocate, didn't he do exactly what the rabbi did not want him to do?
No, he took one examination of perhaps the most critical person that's perfectly consistent with the spirit of pre-objection discovery under SCPA 1404.
But not exactly consistent with the statute, which doesn't list that as one of the safe harbors.
No, but in matter of Mueller, which was a decision by Surrogate Radigan in 1988, there the potential objectant sought to compel production of the decedent's prior wills. Surrogate Radigan, and at the time, SCPA 1404 did not provide, as it does now, that you're entitled to all the document discovery that you are under Article 31. Nonetheless, Surrogate Radigan said that having these documents produced is perfectly consistent with the legislative policy behind 1404 and 3-3.5 is that so potential objectants can make a good faith preliminary determination as to whether or not a contest is warranted. Here, so the difference between this case and matter of Mueller is, in one case you had a subpoena ducis tecum for documents. Here, basically, we had a subpoena ad testificandum for a deposition. But other than that, both purposes were the same, and the system worked. Once Alexander had that discovery, took the deposition of the lawyer who drafted at least 7 of the prior wills, he made a determination not to file objections.
But did the system really work for affecting the testator's intention? If the testator's intention was that his daughter should never have to worry about her brother making trouble, he made trouble, and he made a little bit more trouble than the statute protects him in making.
He took it's absolutely correct, Your Honor. He took one deposition, he took a single deposition, as
Very,
opposed
very,
to
very
subpoenaing.
incautious thing to do, wasn't it, with hindsight? I mean, to bet your legacy
Well,
that we're going to agree with your interpretation?
Well, except, Your Honor, that the only way oftentimes that you can determine whether or not there's a basis to contest the will is to examine, especially when you have, number one, to see if there's been a change in estate plan. You know, one of the sine qua non of an undue influence case typically is a radical change in a long-standing estate plan.
But in answer to the question, he took a risk.
He took a risk, undoubtedly, and obviously based on the decision of the appellate division and the surrogate, he lost.
So I take it your rule is that unless the testator either enumerates all the individuals that we find in this subsection D of the statute, or does a specific statutory reference, then what's ever necessary in order to make a preliminary determination whether to object should be admissible.
Well, I think it's more that the clause has to be clear. I mean, this is a clause that can result in a forfeiture.
Well, that's what
and
I'm asking. What do you mean by clear? From what I've gathered from the argument so far, it's if you have, if you cite the statute or you list the individuals who you indicate cannot be examined.
I'm sure if I had more time, I could think of perhaps there might be another way to make it clear, but precisely. I mean, if you're going to have, under pain of forfeiture, say that you can't do certain things, the will ought to carefully spell them out and not something vague like contest in any manner. I mean, we can go back to cases like matter of Cronin, where it said you can't contest my will. Not only was there a contest, the objections were withdrawn on the eve of trial after full discovery.
Okay, counsel.
Thank
Thanks.
you, Your Honors.
Counsel?
May it please the court, my name is Jack Kent. I represent Vivian Singer, who is the executrix and the petitioner.
What did they do wrong? What did Alexander do wrong in this case? It would seem perfectly logical to want to depose the prior attorney who had drawn so many of the wills. Why was not an appropriate thing to do to figure out whether to bring objections and you know, not in a harassing way or anything that violated the spirit of the rabbi's will, but rather just, you know, why wasn't that a perfectly plausible, rational thing to do that doesn't specifically violate the will?
Your Honor, I think there are two answers to that. One is that Alexander could have obtained the information he sought, which, as he stated in the surrogate's court, was to determine whether it was to his financial advantage to pursue objections and actually file objections without a deposition
What about,
of Mr. Katz.
what about your adversary says it would be a way of finding out whether there would be some kind of undue influence?
I have no idea. I can't imagine what knowledge Mr. Katz, the prior attorney, would have had concerning the drafting and the execution of the will that was offered for probate.
Well, you're making an argument for your opponent in that regard, it seems to me. What you're saying is this was about as inconsequential, irrelevant, and waste of time as I can possibly think, and therefore we're going to take his estate away. That doesn't make sense to me. And the other argument that I think you're making is if he took Mr. Katz to dinner, you wouldn't have had a complaint, but because he did something that gave you a record upon which you could view whatever was being examined, you're saying, well, that violates the statute. Doesn't sound logical to me.
Well, I think it does violate the statute because there is a bright line. And the overall,
So you're saying these are absolute limitations which you can't cross at all?
yes, Your Honor, that's what I'm
What
saying.
if he had taken Katz to dinner? Would that trigger the terrorem clause?
I don't know. It would have depended upon what his intent would have been.
Ask him the same questions that he asked the deposition, got the same answers.
I think that could have triggered the interim clause had we known about it, because he would have opposed. I'd like to focus a little bit on this word oppose. It's one of the words that my adversary has run away from. And when we look at these clauses, the no contest clauses, we're approaching the limits of language. They are as broad as possible. And the modifying phrases,
That's
in
not
any manner.
literally true, is it? I mean, you could all, as your adversary says, if you're writing it now, you'd find a better way to do it.
Yes, but as you said, Judge Smith, that's hindsight. And will drafters are not clairvoyant, and the
Well, then
law should not expect
why,
them to.
maybe we should have a rule that says you have to enumerate exactly who you're not allowing
Well, I think
one of your heirs to depose, or specifically cite the statute so that it's clear the testator's intent is to remain within the four corners of the statute.
Your Honor, I don't think that rule would stop with the depositions in the statutory subparagraph that concerns us here today. I think that rule would require the will drafter to anticipate every conceivable situation.
It wouldn't be such a strain to put in the words, you have the words contest, object to, oppose, attempt to contest, object to, or oppose. You could write a few more words, or take discovery for the purpose of determining whether there's a basis for objecting to or opposing.
Well, once again, that's hindsight, but I think that even under if you want to invoke the rule of strict construction, the word oppose takes us there.
How is
Alexander-
your client inconvenienced?
How was she inconvenienced?
How was she
Well,
inconvenienced by the-
It cost the estate money, which meant that it cost her money. That's one thing.
So that's the main thing, the dollars for the lawyers?
Because also she was upset.
Well, that's her.
By the entire discovery proceeding that.
I suppose this wouldn't
Alexander-
happen, but if your opponent said, we want to take these depositions to just make darn sure that Dad, did exactly what he did, because we agree that it ought to, but we don't want somebody else to collaterally attack this will, so we're going to take these depositions. We're not taking them to oppose, we're taking them to cement.
I don't think I understand your question.
We're trying to help you.
Trying to help you.
Yes.
Right. Then you would.
You tell him, I think this will is good. He says, I think you're right, just to make sure, I'm going to take Mr. Katz's deposition.
Right.
Is that opposing?
I think that it would have certainly contravened, it would have been superfluous. I think that's a hypothetical that's.
It is, but
hard-
my
very
my
hard-
point
hard-
is this.
hard to address.
Your opponent makes the argument that unless and until I file something in surrogate's court, I haven't done anything wrong. And I'm not going to do anything wrong unless I'm pretty darn sure I've got a case. In order to get a case, I got to go talk to people. And all 1404 says is you can do these people, because in the past there's been some question as to whether or not taking these depositions or talking to these people triggers the terrorem. It's now clear that it does not. So I can do all of those, but that doesn't mean I can't do other things. Like I couldn't take his doctor to dinner, and say, I was the old man just before he signed the will. It just seems to me that to make it clear, it's not hard to say, as long as you stay out of surrogate's court and don't challenge it, you're fine.
Well, I don't think that can be the law, because if the minimum standard is the filing of objections, that wipes out the statutory subparagraph we're talking about.
Is there any case that has held that an in terrorem clause is triggered by the taking of depositions?
There's one case, but it's not really on point. That's the state of Cagney, where there was a fight over the taking of depositions under 1404, and because of a prior settlement agreement by the potential objectants, that attempt to depose someone, I don't think the deposition took place.
Why do you think that they
Was deemed
didn't?
to-
Why do you think that they did not bring objections? Why in the end were there no objections? Again, wasn't it a reasonable thing to do to look at that after becoming convinced that the new will was in the spirit of what he had done previously? Didn't they act responsibly, really, in not bringing objections based on what they found out?
I don't think so.
Why did the process work in an appropriate way that's more in the spirit of the will, in that there was no fight, they decided this seems to be in line with what had been done previously? Why is that not a good, responsible playing out of what's going on here in the spirit of the will?
Well, Your Honor, I respectfully disagree that the process worked. In fact,
Why not? Why didn't it?
Why didn't it work, Your Honor? Because even after Mr. Katz testified in deposition that he had no information concerning fraud, undue influence, lack of testamentary capacity, which was in July. It took months for Alexander to finally give this up. There was never any basis
So how did
contest
that,
in the first place.
aside from the cost that you mentioned to Judge Reed, so it took a few months?
Took a few months,
Again,
and
what's the inconvenience to your
It's
client?
it's the psychic pain to my client. The sentence in the will about the two siblings not getting along, I think is an understatement, Your Honor.
So to your mind, the spirit of the will goes the opposite way?
Absolutely,
I see.
Your Honor.
Okay.
The court, even Mr. Cass testified that the rabbi's greatest fear was that his children would fight over his inheritance after he was gone. He obviously was not afraid that that fight would come from Vivian's side. He made her the executrice, and he knew that his son, Alexander, was an attorney, and Alexander had hired a top-notch estate litigator when he heard that the rabbi had changed his will to give Vivian an unequal share. This is unequal distribution. That's the root of this. That's why, in answer to Judge Pickett's question, I don't think that anyone in Alexander's shoes would have been trying to cement this
But generally
will.
speaking, I mean, what we decide has an effect on all the wills, going forward, I suppose. And it just seems to me that the way it reads, I mean, they were trying to give a little leeway. They weren't trying to say, you can't do stuff.
You mean the statute, Your Honor?
Right, because for the reason I said, there's always, if you can't do a deposition, you can call them on the phone. I mean, you can write them a letter, you can take them to dinner. You can prepare to decide whether you want to object or not.
Yes, but I think that's the way the statute is written, or the intention behind the statute. For example, in 1991, before the amendments, could someone have deposed the proponents of the will and the draftsman?
Apparently not, and
No,
that's
no.
why they did it. They said, well, maybe we're too restrictive here. Let's make it clear that you can.
Right, and now if that's going to happen again, the legislature will have to do that. I don't believe this court should accomplish that and then hope that the legislature catches up, which may have been what happened with
Doesn't it seem to you that that safe harbor statute is directed to the will itself? And if you go beyond the will into the motives, for example, of the testator, then you violate the spirit of the statute, which is likely what may have happened here.
Well, I think it's also a bright line, Your Honor. It's
But
a
that bright line is drawn right around the exact will in question, without going beyond the will into the motives of the testator.
Yes, one has to look at the will, although the cases say that there should be a sympathetic reading of the will, taking into account all of the facts, surrounding facts and circumstances. But there's contrary language in other cases which say that absent ambiguity in the no contest clauses, then extrinsic evidence does not come in.
Are we reviewing a pure question of law here, or are there findings of fact that we should defer to?
Well, one of the findings I think there are two findings of fact that you should defer to, Your Honor, in light of what I've seen in the reply brief. One is about the delay. Well, the delay that the surrogate found is a factual finding. I don't think it's reviewable here. And also, there's another factual question that came up, and that was whether Vivian had made an argument in the surrogate's court concerning construction of the no contest clause. In other words, the language about not prosecuting any legal proceeding of any kind in any court, which we relied upon as an additional basis for affirmance, an alternative basis for affirmance. Vivian has the right to do that. And one thing I think that the court should know is, which I brought this out in the brief at pages 11 and 25, but in the surrogate's court, Alexander made no attempt to construe the language of the no contest clauses. To the contrary, his attorney asserted that there was no need to construe those clauses because they were unambiguous. And if you can find Alexander's argument in his answer, which is at page 101 of the record, which he says that this deposition was within the statute. That was his only argument. So the court will make up its own mind about the the intent expressed by the testator, that is a question of law reviewable here. But I don't think the court should hear arguments on construction from Alexander at this point, since he did not make any of those arguments, and in fact took the opposite position in the surrogate's court.
If an heir believes that there could be undue influence or a question of competency, how do they tackle that issue if faced with clauses like this?
If the heir strongly believes that, the heir should take the maximum advantage of pre-objection discovery, which is the depositions of the 4 categories of witness plus full document discovery, even from non-parties under Article 31 of the CPLR. Then that heir has to make a decision. That's simply, it's inherent in the statutory scheme.
Say they want to take the deposition of some medical personnel that may have been present. Presume this is somebody that was in a hospital. Can they do that under 1404?
No, Your Honor, they have to wait until after the objections are filed and then go forth under Article 31.
Doesn't that put you in a funny situation? In fact, if you wanted, not this case, if in a case that somebody wants to influence a testator, they would put an terrorem clause in the thing and then influence them, and then say they can't come back and talk to your doctors. The minute they do anything that tries to show that I influenced you, I mean, they're saying to themselves, of course, they lose.
I think that's inherent in the human condition and in the situation.
Well, the law
all
can
heirs
fix that.
face.
The law can say you can investigate, and once you investigate, if you want to object, you do it at your peril. If you investigate and elect not to object, then you're okay.
The legislature could do that, but it has chosen not to, Your Honor. And that's the law that all of us must respect.
Okay, counsel, thank you. Counselor, rebuttal?
Unless Your Honors have any questions for me.
Right, well, if what you said and what I'm suggesting at some point is true, then we don't even need 1404, right? We can just say, do any depositions you want.
No, I don't think that's true, Your Honor. If 1404 does serve a salutary purpose, at some point, it puts the beneficiary needs to make up his or her mind whether or not there's a good faith basis to contest the will.
Right, but to say you can depose these people, I mean, why say that? Why not say you can depose anybody?
Well, it's not anybody. What we are talking about here is perhaps the most critical, when you're evaluating undue influence, as indicated by Judge Radigan in matter of Mueller, perhaps the most critical witness. I mean, here all of a sudden, the attorney who drafted Joseph Singer's will was not his attorney of long standing. It was a new attorney. This will was done within less than a year of the last will that Attorney Katz had
So
done
whose
for
judgment
him.
is that? You just make the judgment on your own?
Well, I think it's going to be the surrogate's judgment in part in terms of whether or not, to what extent this is done in good faith, whether this is legitimate.
Yeah, but basically you make the decision and you do it like you did here, and then you take your
peril.
chances.
Absolutely.
Okay. Thank you.
Thank you, Your Honors.
Thank you both. People versus Sims, 156